My name is Raymond Karchevsky, and I am living Christ. I would like to share with you today a blast from the past. It is an address that I had prepared for an appearance before the Josephine County, Oregon court concerning the crimes that have been committed against this living man. The court date on this particular situation was November the 12th, 2002. Pay close attention, for this reveals to you the nonsense of the Satanic court system, the judicial system, and points out the fact that they have no power over living men. They only have power over fictional persons that they, the government, the fictional government, has created. That is a fact that is not known by just about all of you, and it explains why you are slaves to a fictional government. It starts out with a note. Since I have routinely been obstructed by the court from speaking in my defense in my last 7 appearances in this case, now before the state of Oregon Circuit Court for Josephine County, I have decided to post the contents of this address publicly on the internet prior to the hearing, only with full disclosure of the facts which otherwise would be narrowly controlled by the courts. May a slumbering populace awaken to the power of truth, which no judicial body, acting beyond the scope of the United States of America Constitution, may stifle. By the way, 2 judges, 1 district attorney, and 1 sheriff, not a sheriff's deputy, but a sheriff, were removed from their offices as a result of their mishandling of my case. The government does, in fact, act on these matters, but very, very quietly. The public is never aware of the PR that is being imposed upon them. This is the reason this living Christ is ignored today. For they have no power over living men who assert themselves. This notice was edited on July 7th, 2019, today. Sir, the name of the defendant listed on the complaint is not this living, breathing, flesh and blood, sentient, natural person who is speaking to you. The name on the complaint, spelled in all capital letters, is my private property, my common law copyrighted trademark, trade name. I am the secured party and holder of that common law copyrighted property. I am not that juristic person, that legal fiction. Yet this court and the Josephine County Sheriff's Department has seen fit to arrest, imprison, and hold me hostage for 34.5 days in the Josephine County Jail for crimes that they allege were committed by the defendant. The unauthorized use of that copyrighted trademark, trade name, continues to carry with it a fee of $500,000 each and every time its unauthorized use is recorded in these proceedings. For purpose of this hearing, you may address me as secured party. I, this living, breathing, flesh and blood, natural person, natural man, do not consent to doing business with this court. From my first appearance on September the 12th, 2002, to my seventh appearance on October 15th, 2002, I have repeatedly, specifically, and unequivocally asserted that I did not consent to do business with this court. Nothing has changed. I reserve my rights at all times and waive none of my rights at any time. My appearance today, here, as in other appearances, is special. I am not here voluntarily. I am appearing here against my will. The agreement made with the court on October the 15th for my return to the court on this date, November the 12th, 2002, can be seen by any reasonable man as an unconscionable contract. It was imposed upon me by you, sir, Judge Kuhn, in an atmosphere of extreme duress. My physical condition on that day was naturally and markedly affected by my 33-day hunger strike in protest over my false arrest and lengthy imprisonment by the Josephine County Courts and Sheriff's Department. I was given neither time nor means to prepare for a jury trial scheduled by you, sir, Judge Kuhn. For that date, October the 15th, 2002, after only a one-day notice. Is that reasonable? The agreement made for a postponement could well be likened to a kidnap victim or a hostage being told by his captors that he would be released from their unlawful custody if only he promises to voluntarily return and place himself back into their unlawful custody at a future time and date. No reasonable person would accept such unconscionable terms as voluntary agreement, and therefore constitute a legal contract, a valid contract, I should say. As such, the unconscionable contract foisted upon me on October the 15th, 2002, by you, sir, Judge Kuhn, has no force of law behind it, and therefore is null and void. At that appearance, I asked for the postponement in order to look at my options in seeking counsel. I had not at any time engaged, ratified, or accepted Mr. Peter Smith of the Josephine County Public Defender's Office to represent me and act as my attorney in these matters. Mr. Smith was appointed to represent me against my will and my wishes by you, sir, Judge Kuhn. Mr. Smith will attest to that fact. Mr. Smith added that since he was appointed by you to represent me in this case, so must he be discharged by you. Let it be so. I have since learned that no attorney can represent this living, breathing, flesh and blood natural man in his private capacity in any action brought before the court, since that is the very core of this issue, that of a sovereign who refuses to waive his rights by accepting the services of an attorney, which would diminish his capacity to represent himself. I have therefore ruled out the option of securing legal counsel to represent me. On 7 prior occasions, I was brought to face this court against my will. I have repeatedly challenged the court publicly to prove its jurisdiction in writing over this living, private, breathing, flesh and blood, natural person. The court has repeatedly evaded the issue and refused to follow the law. The law states that when jurisdiction is challenged, all proceedings must come to a halt until the court is able to prove jurisdiction. On Friday, November 8th, 2002, I presented District Attorney Clay E. Johnson with the document Conditional Acceptance Request for Proof of Claim. I did so in an effort to expedite the administration of justice and bring closure to this matter. Neither Deputy District Attorney Neil C. Morey is prepared to address this proof of claim issue at this time. This matter that is before the courts may be resolved here and now. If Deputy District Attorney Neil C. Morey, in his private capacity as claimant, is not prepared to respond to the proof of claims as enumerated and or establish clear jurisdiction over this private, living, breathing, flesh and blood, sentient, natural man, then I ask this court for a week's continuance to afford Mr. Morey the opportunity to establish such proof of claims jurisdiction. If no such proof of claims can be established within the 10-day period extended, District Attorney Clay E. Johnson, Deputy District Attorney Neil C. Morey, and or other members of his staff who have been involved in the prosecution of this case. The prosecution will be found in dishonor and will have admitted damage and injury to this living, breathing, flesh and blood, sentient, natural person, this private man. Without the prosecutor's establishment of such claim, proof of claim, this case must be dismissed. Signed, Raymond Ronald Karchevsky. Common law copyrighted autograph. There you have it, folks. You do understand, don't you, that this proves that fictional government and courts have no jurisdiction over its creator, the living man or woman who has not consented to becoming or accepting the mantle of person, fictional person, created by a fictional government.